Thank you.
Next is Teresa Younger, followed by Senator Edith Prague.
Good afternoon, Senator McDonald, Representative Lawler, and members of the Judiciary Committee. My name is Teresa Younger, and I am the Executive Director of the Permanent Commission on the Status of Women. Thank you for the opportunity to testify today on behalf of the Commission to reaffirm the Commission's support of extending equal legal rights and responsibilities to same-gender partners through civil marriage. Some may ask why the PCSW is taking a stand in a debate over same-gender marriage. In fact, we at the PCSW regularly consider whether particular issues are women's issues as we assess whether proposed positions fall within the scope of our statutory mandate. Our determination on that scope depends on the affirmative answers to two or more of the following questions. Does the issue disproportionately affect women? Do women seem to care more broadly, more deeply about an issue than men do? Or finally, does the issue involve policies or practices that grant or withhold benefits to individuals based on gender and that are not grounded in and reinforce the stereotype notions of gender roles, what girls and women do or shouldn't do solely based on the virtue of the fact that they are girls and women and or boys and men? In our view, same-gender marriage and more generally, all issues related to full equality with respect to gays, lesbians, and bisexual individuals fall squarely in the third category. Connecticut's current marriage policy, which would afford access to the rights and responsibilities associated to marriage only for individuals in opposite gender couples, denies the benefits of many other individuals solely on the basis that the gender of their partners that they wish to marry, and is grounded in and reinforces stereotype notions of what the roles of men and women should be and should play in their intimate associations. As the United States Supreme Court acknowledged in 1965 in declaring unconstitutional the state statute that prohibited interracial marriage, the freedom of choice to marry is a fundamental civil right and a right that has long been recognized as one of the vital personal rights essential to the order to pursue happiness for all free people. The PCSW agrees and urges this committee and the General Assembly and the Governor to extend fundamental civil rights to all residents in Connecticut, regardless of their sexual orientation. As an initial matter, we should remember that though the institution of marriage does not have a long history, the rules governing civil marriage in our state have never been etched in stone, and thankfully so. Rather, they have evolved over time in the direction of broader access, greater equality, and more respect for the privacy and individual choices essential to liberty. Under Connecticut law, married women are no longer deemed the property of their husbands, nor denied the right to own their own property or bring suits in their own name. People of all races can marry, and men and women can marry across racial lines. Alimony is both for men and women. Joint custody of children after divorce is no longer an anomaly. Each of these changes was controversial at the time, but each was required to correct an injustice. However, even if we form a marriage codified in Connecticut's law had been in place since the beginning of time, the fact would not necessarily lead to the conclusion that the perpetuation of marriage in its historical form works no constitutional injustice. The argument is that no persuasion with respect to same-gender marriage argument is that no persuasion with respect to same-gender marriage than as similar assertions would be made as opposed to the treatment of the laws of women and people of color, who otherwise would cite long traditions as a support for their views. There are, as here, traditions of injustice that were sorted out as a justice in society made decisions around liberty and equality of law. Like the legal changes that recognize property rights for married women, custody and alimony rights for divorcing fathers and husbands, and the rights of individuals to choose marriage partners across racial lines, the changes you are considering today are necessary to correct an injustice. Connecticut law now denies lesbians, gays, and bisexual people the freedom to participate in one of our most important civil institutions solely based on the gender of their partners for whom they have committed. Connecticut has always been at the forefront of efforts to eliminate discrimination based on gender and sexual orientation. In our adoption statutes permit homosexual individuals and same-sex partners of biological parents to adopt. Our anti-discrimination statutes forbid discrimination on the basis of gender or sexual orientation in housing, employment, education, public accommodation, credit practices, licensing, and even golf club membership. We hope that the committee and the members of this committee will look to change the laws and ensure equality for all. We also are in support of Senate Bill 1449 and are also in support of Senate Bill 1447. Thank you.
Thank you for your testimony. Are there any questions for Ms. Younger? Representative Adinolfi.
Thank you, Mr. Chairman. Just a brief question. In your testimony, you mentioned bisexual couples. How would we handle that if you had 3 people living together that were bisexual and loved each other equally?
We're not talking about 3 people. We are talking about 2 individuals making a decision about where they want their lives to go. When we talk about bisexual couples, we're not talking about 3 people or 6 people. We're talking about the intimate decisions of 2 people to advance their lives together.
I didn't interpret it that way. Thank you.
Senator Cappiello.
Thank you, Mr. Chairman, and thank you very much for your testimony. If I can understand this, I just want to make sure I'm clear. We're really talking about 2 issues that are separate, but they're still conjoined. One of them is the issue of what we call this. And right now in Connecticut, we have, under Connecticut state law, we have civil unions that give all the same rights and responsibilities of married couples within our state, correct? Mm-hmm. So there's the issue of the name. But the other issue regarding other rights that are attainable under marriage that are not attainable under civil unions in Connecticut, getting back to Representative Morris's question earlier, what other rights would be attainable if we were to change our Connecticut law from civil union to marriage?
Unfortunately, I don't have that fact sheet on me right now, but the people that come up after me can identify what those rights are. But it should be noted that just because you call a water fountain for whites only and a water fountain for blacks only doesn't make it equal. And what you call something is important. And if we are going to call and respect the rights of gay and lesbian couples to be in partnerships together, then we need to do that, and we need to call it what it is. And that is marriage. It's the same marriage that I entered into with my husband. It's the same marriage you entered into with your wife. In regards to the level of love and commitment you want to take forward, why call it something different?
And like I said, that's a separate issue. We can debate that, and there are different points of view. I just want to know from because this is going to be a major issue that we're dealing with this session, what rights are we talking about that aren't included under our civil union law? And you testified on behalf of this, so I didn't know if you knew what those rights were.
I don't have it on me. I'm sorry.
Okay, thank you.
Is there anything further from members of the committee? If not, thank you very much.